I don't know. After hearing him calm and talking about the tether story, it's probable.
Let's go down to the county attorney's office. I think you'll find a lot of humans down there.
All right.
No disrespect.
Stop driving.
I'm flirting with the judge in front of my dad.
Probation. What's going on? This is Colin. How's everybody doing? Happy Monday. Happy Thanksgiving week. It's going to be a good week. I can feel it. We're all going to have a really good week this week. Unless you're Judge Clarke or Judge Washington. They had some rough days. They had some fun people. First clip, Judge Clarke. Some drama. Still love Judge Clarke's new haircut. Kind of like my new haircut. Well, mine's not new, though. And then I've got 3 in a row in Judge Washington. I'm not going to say anymore, so let's get into it. But before I hit that play button, you already know what to do. Like and subscribe, do your jump kick backflips. And if you'd like to donate, link trees down in the description. All right, let's go.
Mr. Austin, you been before the court today for your arraignment?
Oh, I should say, this guy is not this isn't the sovcit. This is the guy before him. I just kept this in this clip to buffer Judge Clarke a little bit.
All right, so you've been charged in case number 15 CF 2906 with felony battery, a third-degree felony punishment with 5 years in the Florida Department of Corrections and a $5,000 fine. Count 2, strong arm robbery, which is a second-degree felony punishment with 15 years in the Florida Department of Corrections and a $10,000 fine. Let's see, in 13 CF 1827. That's a violation of probation. Those are both violations of probation. Probation looks like for that robbery, strong arm robbery.
No.
And possession of a
No firearm.
no firearm. Yeah, strong arm robbery. All right, sir. You're not represented by an attorney at this time. Do you wish to be considered for the services of a court-appointed attorney?
Yes, sir, for the VOP. And I filed for a motion for a preliminary hearing on pro se on the new charges.
All right, you don't want an attorney to represent you on the new charges?
No, sir, just the VOP charges.
Has he put out a financial affidavit?
Yes, sir.
All right, sir, if you'll raise your right hand, I'll just take some information right now.
Yes.
All right, sir, state your name.
Jeffrey Marshall Glenn Austin.
Austin, you're asking for the officer's services of the public defender. Are you employed at this time?
No, sir.
When's the last time you worked?
Before I came in here, sir.
Where was that?
Bath Fitters in
Okay.
Cincinnati, Ohio.
Okay. And do you own any property or any land or anything like that?
No, sir, I do not.
Do you have any money in the bank?
No, sir.
Do you own any vehicles?
Not anymore, sir.
I'll appoint the office of public defender to represent you in the new charges. In the violation of probation. You want to represent yourself in the new charge?
Yes, sir, for a preliminary hearing.
All right. I'm not going to have a preliminary hearing today, so.
Your Honor, the information was filed 12 days after his arrest, so I don't believe he's entitled to an adversary.
I don't think so either, but what I'm going to do is I'm going to probably issue an order on that, denying the motion for preliminary hearing if you're not entitled to one. I believe the state has filed their information within the specified time. Do you still wish to represent yourself on that?
I guess I would like an attorney now, sir.
I'm going to appoint the public defender's office to represent you on everything, okay? Sir. I'm not going to rule on that if they'll ask for a preliminary hearing if you're entitled to one, okay? All right. All right, Ms. Jewell?
Your Honor, since I have not, since he was a self-rep up until now, it looks like we have a 15, a 10, and a 13 VOP or These are all awfully old cases.
What I'm gonna do is, if you want to set it, I'll set it for December 21st. That's our next pretrial date. If you need to advance it on an earlier docket, you can place it on an earlier docket.
Yeah, because I would like to get out and see Mr. Alston.
All right. So I'm gonna put you on my next pretrial docket. If Miss Jewel needs to put you on an earlier docket, she'll do that.
Thank you, sir.
Sure.
Okay, I'll get in contact.
All right, do we have another pro se? Mr. Baker, come on up.
All right,
Sir?
here's the star of the show.
Come on up. All right, Mr. Baker, you're before the court today for your arraignment. And let's see. You're not, have you hired an attorney?
No, sir.
Do you plan on hiring one?
No, sir.
Are you gonna represent yourself, or do you wish to
Yes,
have a
sir.
public defender to represent you?
No, sir. I'm representing myself.
All right, you're before the court today for your arraignment. You've been charged by way of an information with possession of a cocaine, possession of a controlled substance, but count 1 and 2. Those are both third-degree felonies, punishable to 5 years in the Florida Department of Corrections and a $5,000 fine. You have a count 3, which is fleeing or attempting to elude high-speed reckless. I believe that should be a second-degree felony, punishable to 15 years in the Florida Department of Corrections and a $10,000 fine. Count 4 is drive my license, cancel, suspend, or revoke third or subsequent offense. That's a third-degree felony, punishable to 5 years in the Florida Department of Corrections and a $5,000 fine. And count 5, possession of marijuana less than 20 grams, which is a first-degree misdemeanor, punishable to 1 year in the county jail and a $1,000 fine. So you're looking at a total of about 30 years in the Florida Department of Corrections if you're convicted of everything and you get the maximum sentence. And you're still wishing to represent yourself?
Yes, sir.
Or if you'll raise your right hand to be sworn in.
Yes, sir.
All right, Mr. Baker, state your name.
Lee Baker.
And Mr. Baker, you have asked to represent yourself. Is that correct?
Yes.
How far did you get in school?
9th grade.
Okay. And so you can read and write?
Yes.
Okay. Are you employed?
No, sir.
All right. How do you make a living?
I'm unemployed right now. I was living with someone else.
Sir?
I'm unemployed. I was living with someone else. I just got out of jail about 5 months ago.
Okay. Well, what is your trade?
I have my own business,
All right. What kind of business?
a cleaning business.
Okay. And have you ever represented yourself before?
Yes.
All right. Let's see. Are you under the influence of any drugs or alcohol today, which would affect your ability to make this decision to represent yourself?
No.
Have you ever been diagnosed with a mental illness that would affect your ability
No, sir.
to make this decision?
No.
Right? You understand that attorneys are trained in the rules of evidence, criminal procedure, and the law, and they're there to assist you in preparing for pretrial motions, preparing for pretrial hearings, and to participate in discovery, and also preparing for trial.
I comprehend that very well.
All right, and sir, you understand that if you're representing yourself, you'll be held to that same standard.
I comprehend that.
All right, and I cannot assist you in any way. The state attorney would not be able to assist you in any way. Is that correct?
I comprehend.
All right, and you still wish to represent yourself?
Yes.
All right, Madam Clerk, if you'll print out the information, and Deputy Dexter, it's okay if the clerk hands the information to Mr. Baker? All right, Madam Clerk, if you'll do that. Mr. Baker, when you receive that information, I'm gonna ask that you enter a plea at this time.
I like to file 2 motions on the record as well, sir.
I want to do your arraignment first.
All right.
All right, whenever you're ready, you'll let me know and you enter your plea.
I end up pleading not guilty.
Okay. All right, you're filing motions.
Yes, sir. I
You
got
have copies for the state.
Yes, I do.
Okay.
I got a declaratory judgment, and I want to furnish this bond to the clerk
You file it. Go ahead.
for my release from the Bay County Jail today.
Okay.
That's declaratory judgment. That's for the clerk only.
Now you're providing a copy of the state, everything you've given the clerk.
The bond, I shouldn't have to give the bond. The bond goes straight to the clerk. The declaratory
Anything you
judgment.
file that you want me to consider, you have to provide a copy to the state, sir. That's you're representing yourself. You have to know those rules. If you don't, you're gonna
I
mess up.
understand that.
If
but-
you're not providing to the state, I'm not gonna consider it.
Okay,
And the clerk doesn't make any determinations on that. All the clerk determines is whether you're indigent or not.
I'm not talking about the bond for the declaratory judgment. I'm talking about the bond for the clerk to release me today. I filed my eligible obligation.
What are
with the
you
clerk.
talking about?
Sir,
What are you talking about?
I'm talking about eligible obligation on the USCA.
Oh, you talking all that kind of stuff. I'm striking all that. And if I hear it again, I'm not gonna let you represent yourself. I promise you. I mean, he's already entered a not guilty plea. We'll set this for a pre-trial. We'll set it for, don't ask me any questions like that, sir. I'm not answering any questions. If you want to file a motion, file your motion. We'll set it for our December, when's that motion day in December? December 19th at 9 o'clock. Sir, you may, if you're going to do the sovereign citizen, all that, you may want to consider having the attorney.
I'm a private citizen, sir. I'm not a sovereign citizen. I'm a private citizen.
Listen
I'm
to
a
me.
United States national.
If you're going to pursue that, you may want to reconsider representing yourself.
No, sir.
But I'm not going to pay attention to any of that, and I'm going to strike all that. So
Okay.
we'll see you
No
December
problem.
19th at 9 o'clock.
It's no problem.
That's
Oh,
enough. I don't want to hear another word.
okay. I'd like to also.
Another one, I don't want to hear another word. No, put him out.
Put your hands on me like that.
Hush. Get him out of the courtroom. I don't want to hear another word. I just heard another word, Mr. Baker. Hush. Whoa. Mr. Baker, I'm going to appoint the Office of Public Defender to represent you. I'm going to find that you're not competent to represent yourself at this time. I'm going to reverse my decision. The Office of Public Defender is going to represent him. We'll keep it on that December 19th date. I just did. All right, who's ready?
Here I have,
I'll read
I have Ashton Solomon.
Come on now. Y'all close that door where I can't hear him or he gets in any more trouble.
Here, this is case 23.
Close that door where I can't hear him. Oh man, when was the last time you saw someone physically physically removed from a courtroom? Let's just change the word that I know works in a sentence. It was good. It was good. I like Judge Clarke. All right, now we're going to Judge Washington. We've got a lot of things going on in Judge Washington today. I don't really even need to talk about it. Let's go.
Ashley Jordan requesting a practice under MCR 8.120 under the direct supervision of Sandra White.
Permission is granted.
Thank you, Your Honor. Mr. Booth, are you present?
Yes, I am. Sorry.
Please state your name,
Tyler
sir.
Booth, by the way.
Once again, I think you broke up.
Tyler Booth.
Thank you.
Yep.
We're here for a review. It appears that Mr. Booth is making very small payments on this.
Yes, Mr. Booth, Mr. Booth has been trying to make payments. His income is low at the moment. Mr. Booth, when do you plan on making another payment?
I believe this Friday coming up.
Are you able to get back on track? with your payment?
I'm not positive on it, so I can't agree to it.
Mr. Booth, what's going on with you? Are you working?
No, I'm not. I'm a stay-at-home dad right now.
You're paying $50 today to the court, Mr. Booth?
I did not say that. I said I can make a payment on Friday, and I can't agree to make a $50 payment.
February 26, 2024, will be the next court date.
When is it? I'm sorry.
February 26th.
Okay. At what
10
time? Okay. At what time?
At 10 a.m.
Thank you.
for a review. Mr. Booth? We've been doing this for a while.
It's gonna go on for a while.
We'll do this review in person. We need to have a ability to pay hearing on this. So I'm gonna have an ability to pay hearing.
I'm sorry.
I'm gonna have a hearing and whether you have the ability to pay.
Okay. I got the ability to pay. I just can make small payments. I can't make what you guys are asking me to make or pay right now. I'm sorry. So as long as I'm making a payment,
I'm gonna
there
make that
shouldn't be a problem.
determination myself. Well, you don't get to determine that. That's why I'm gonna make that determination in person.
Okay, well, I also have other things in my life that's going on, and we've talked about this. You didn't say anything. You didn't make no fuss last court date. You said okay and have a good day. Because why? I made my payment. It may not have been a $50 or a $25 payment like you guys are demanding, and I never agreed to.
Booth, I would advise you to stop talking at this time.
Well,
We'll see
see,
you
I
here.
have rights, and I have a right to let my voice be heard, just like you guys have a right to let your voice be heard. And as long as I'm making a payment, there can't be no consequence.
Oh, really? We'll see you here in person. Okay,
Okay.
thank you. State of Michigan versus Alexander Kelly, 19 FB 1617.
Rachel McDuffie for the people.
Assistant Public Defender Sandra White on behalf of Alexander Kelly. Mr. Kelly, can you state your name for the record?
Alexander Michael Kelly.
Good morning, Mr. Kelly.
Good morning.
All right, we're here for a review today. And apparently, when we were here at the hearing on October 16th, Mr. Kelly was told to get back in touch with the ABI program and get into that program. My records here show that there's no proof that he's done that. And he hasn't contacted his agent since then. And at this point in time, she's filed a formal violation. So I'm going to arraign you on the violation. It indicates that you committed a non-technical violation, which means that you can be subjected to the original maximum penalty that you have not reported to your probation agent since your last court hearing, and you were discharged from the ABR program on September the 13th, 2023 for non-payment and lack of attendance. You have a right to have a hearing on that matter, at which time, if it is found that you are in violation, you could be subjected to the original maximum penalty. The recommendation at this time is for 60 days in the Washington County Jail. Ms. White.
Mr. Kelly, you would like to admit to the violation, correct?
Yes. I also had some questions too.
Different from what we talked about?
Yeah. I just had some questions for the judge. I mean, that's fine, but I was just wondering, like, I've done a lot of the classes already, and I've done more like before COVID. So I was wondering if those if those were just the reason I didn't go to the classes was because I had to start over, and I was only like 3 classes away from being finished. That's why I didn't go there, because I just didn't want to have to start over. I've been going through this since before COVID. It's been over 5 years, so I'm just kind of ready to get it over with. And if I could do, the jail time just to complete the probation, that's fine.
So you do want to admit to the violation?
Yes.
Okay.
Please raise your right hand. Do you swear or affirm that the testimony you provided will be the truth, or that you're going to provide with the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Sir, is it true that you failed to re-enroll in the ABR program as was ordered, and you failed to reach out to the probation agent?
Correct. Yes.
Thank you. I find that there's a knowing and willing Admission to the violation. Are you satisfied, Ms. McDuffie?
Yes, Your Honor.
Yes,
Ms.
Your Honor. Yes, Your Honor.
All right, as to the sentence, what would you like to say on behalf of your client?
Well, Your Honor, Mr. Kelly would like to know if he does do the 60 days, will that close this case? And will he still have to pay fines and costs?
He'll still owe his fines and costs, but he can close the rest of the case.
You understand that, Mr. Kelly?
I do. Can I do community service for the fines and costs?
You have to fill out a hardship form for me to review to determine whether or not you're eligible for community service.
Okay. And is there any way that I can just like restart the class instead of doing the jail time and then like or not restart it, but start from where I was at and then just finish the couple classes? Or
I don't have the ability to make that determination. It's to the ABR director.
okay, that's fine.
Well, then, Your Honor, since it sounds like Mr. Kelly may want to try to restart the class, is that what I'm hearing, Mr. Kelly?
Not restart it, but start from where I was at. I mean, if I
That
can
may
maybe
not be an
talk to-
option. That may not be an option. We don't know.
Right. Yeah.
So can we get 30 days for Mr. Kelly to try to become compliant? Or Mr. Kelly would, okay, he's saying
Yeah.
yes. 30 days for Mr.
Yeah,
Kelly to try
I'll
to
call her
become
right now
compliant.
after this. Yeah, I'll call her and find out right now after this.
We did that twice already.
Actually, I didn't have any contact with her this since the last court date.
But you chose not to, sir, when I told you to do that.
You're right.
I guess I would just like to say that now he and I have talked. He does have a better understanding. He has asked questions of this court and of me. So I would ask for one more chance.
Ms. McDuffie?
I'm a little disturbed, Your Honor, because Mr. Kelly is making it pretty clear, I think today, that he just wants to be done with this in whatever the path of least resistance is for him. Even as it relates to fines and costs, he wants to know if he can get out of paying those if he goes to jail. And even trying again with these classes that have been an issue for, gosh, I think back in May, we were here when I'm on a violation for the classes, and he asked, how long do I have to do these? You know, when can I be done with these? You know, so it's I think always an attempt to sort of, I don't want to say short circuit, but just this general like avoidance of an attitude that we've had about this. So to be at this point and to even say, well, I want to take the class instead of jail, but I don't want to have to repeat everything. I'm not, clearly the effect that we would hope that probation would have is not being had, I would assume, because he isn't complying with the full terms of probation. So, but he is not giving himself an opportunity to benefit from this at all. So I don't know what sort of, I don't have a problem with adjourning the sentencing on the VOP to determine where we're going to go from here. But I think there's an attitude that is not going to be compatible with compliance for anything here, even administratively. Continuing to go this way. So I leave it to the court, but community service is not just an alternative for fines and costs. It's a demonstrated hardship. So, Mr. Kelly has said at some point that he, I think, had an issue paying, but I'm just concerned about the underlying attitude towards all of this. So I would like to see Mr. Kelly engage in the classes and actually get something out of them if at all possible. But if the court feels that that's not possible and jail is the best solution, then I defer to the court.
Thank you. Mr. Kelly?
Yes, ma'am.
Mr. Coleman, please stop unmuting your device. Mr. Coleman, please stop unmuting your device. Mr.
I'm
Coleman.
trying to fix that.
Mr. Coleman, remute your device
Yes.
and mute it. Mr. Kelly.
There you go.
Mr. Coleman. All right, Mr. Kelly, I apologize.
No, that's fine.
Is there something you would like to say before sentence?
If we can adjourn it, that'd be fine. as far as the fines and costs, I was thinking maybe I could pay some and then maybe do some community service. I don't know, but you said I have to fill something out, so.
Did you hear anything the prosecutor said?
I did hear what she said, yeah. And I understand it's kind of like just saying like, oh, I'll just, do this and that. And it's, yeah, I understand what she said and I agree. But the guy kind of threw me off.
All right, this is what I'm gonna do. I'm gonna adjourn this matter for 3 weeks to December 11th, 2023 at 10 a.m. in person. No, make it 11 a.m. in person. Either you're in that class, I'm gonna give you the 60 days.
Okay.
Can I get that date one more time? I'm sorry.
December 11th.
Damn.
Court will call the case of the State of Michigan versus Jamila Scott Williams, case number 14S00540.
Well, thank you, Your Honor.
You're welcome.
Rachel McDuffie for the people.
Sorry, Rachel. Tom Pietrowski on behalf of Miss Jamila Scott Williams. Exercising the patience of Job again today, Your Honor.
I don't know that you've seen that today.
It's been trying, I can tell.
Yes, it has been. So speaking of that, where's your client?
Yeah, speaking of that, I can put you right over the top on this one. She's extremely, I guess, technologically challenged. She was with us for a while and now she's not here. I officially I'm not even retained on the case, but I know I was previously. So I got a call, a 911 call from her. I almost said 411. That really shows my age. 911 call from her this morning. Just basically asking me to look in on what's going on. So she did inform me that she does know about the probation violations and the allegations alleged in that. She said she's done some of it, but she just has not provided the necessary proof to the probation department of her completion of the terms. And that's about all she has shared with me.
Well, I can tell you, I don't think she showed up today. So I don't think she's been here.
If I'm here at the court, it was under the name Tim Tyking.
Okay. All right. Well, she is no longer here.
No.
We have somebody named Wing Tech who just.
I've tried to call her and there was no answer on her phone either. Neither is accepting text either. So I have no client or even purported client.
Okay. Well, Miss Stroud. Good morning.
Good morning, Your Honor.
Well, Miss Jamila Scott Williams was present apparently and is no longer now. Are you still what is your recommendation at this point?
Are we able to do a short adjournment or do we not really have that available?
I can do one are you available on the 27th?
Me? Oh, I was like, me, yes.
That's quite funny. If we can do like 10 or 11 o'clock, that'd be great.
Sure. I can do 11. Well, let's do 10. Let's do 10.
Okay.
And could I just inquire of the court and Agent Straub as well? I know that some of this is compliance with requirements, but I'm also concerned about her substance use because it was mentioned in there that she sounded intoxicated, I think, when she called in. Do we have any updated lab or testing results for her?
Yeah, she's on some medications. I'm pulling her up right now. I'm not sure if she's missed a test recently. I have to look it back up real quick. Yeah, she intermittently misses tests, so I don't have anything that is a concerning positive outside of her medications. But I also have no idea where she is, and I've tried to call her a few times, can't get a hold of her. I'm just concerned that she's using, but I'm also concerned based on the voicemail that she left me. There was some concerning information in there. Not necessarily with regard to her use, but other things that are happening in her life. So I do think it's important that she's here. So if she doesn't appear at the next date, then I definitely will still be recommending jail time.
Shannon, I will email you her, at least her boyfriend's phone number, which is probably the best phone number for anybody.
I think I have both. I called a
Okay.
couple different ones, but I'll take it still and try again.
So, Mr. Piotrowski, are you able to be here in person perchance on that date?
I think I should be able to. I have got a 8:15 sentencing in Adrian. I think I can make it in person.
Let's just make it 11 then.
Okay.
Okay, at 11 a.m. in person. And I will see you all then.
On that note, have a good Thanksgiving, all.
You too.
Thank you.
Bye-bye.
All right. That was fun, right? Got a sovcit that got physically removed from a courtroom. Then we have 3 people in Judge Washington that all have to show up in person. Generally means they're all going to jail. Second guy, he was confused. I don't know what his issue was. He wasn't listening. I agree with everything that Rachel McDuffie said. And then he just totally blew it off. He's going to jail. That last woman, I just kept that clip in there because it was kind of a fun interaction at the start of it. That first guy, though, oh man. First guy in Washington. A lot of fun people today. Got a lot of good content today. Trying to grab as much content as possible. Because the courts are going to be closed later in the week. So I want to make sure I got videos. Any that. If you haven't done it already, please like and subscribe to your Jump Kick Backflips. If you would like to donate, I would be very much appreciative. Link trees down in the description. Until next time, bye.